Today at the Business for 2023 webinar, Aaron Torcella and I talked about some of the groundbreaking decisions by the National Labor Relations Board, in particular the CMAQ construction case. Traditionally, if an employer with a workforce that was not unionized received a demand from the union that it represented the employees and wanted to be recognized as their representative, the employer was free to decline that request and require the union to file with the National Labor Relations Board a petition and have a secret ballot election. In the CMAQ case, the board drastically changed that procedure and put the burden on the employer, so that now if you're an employer and you receive a demand for recognition from a union, you have two options. You can either accept that recognition and begin to bargain with the union, or you are required to file your own petition with the labor board seeking an election. And you have but 2 weeks to do that. If an employer fails to act in this regard, or if an employer fails to act in this regard, the board has the authority under the CMAQ case to issue a bargaining order and require the employer to recognize and bargain with the union. Likewise, if the union files an election petition or the employer files an election petition, and then there are unfair labor practices committed while that petition is pending, the board has announced its intention to dismiss the election petition and issue a bargaining order. In other words, require the employer to recognize and bargain with the union. This decision radically changes the landscape of union recognition, presents an obvious disadvantage to employers, but a significant disadvantage to employees as well, because it takes away the opportunity for education and communication over the advantages and disadvantages of union representation, and critically, significantly reduces the opportunity for employees to have a secret ballot election, to go into the voting booth unencumbered by pressure from coworkers or from the employer, and in the privacy of that voting booth, make a determination as to what's in their best interest, a determination that no one will necessarily ever know the answer to, and obviously fundamental to the labor relations process we have in this country, and critically to democracy in the United States. Aaron and I are going to explore further the implications of the CMAQ decision and some other recent activity by the Labor Board in a webinar to be held this Thursday, September 7th at 1 p.m. And there is a link available on our website and connected with this short announcement that allow you to sign up for that webinar so we can explore in further detail the significance of this decision and others that the board has recently enacted. Thank you very much. I hope to see you at the webinar on Thursday.